All right, today we are tackling a huge question, one that seems like it should be easy, but has been tying thinkers in knots for centuries. What exactly is law, and where does it even come from? Let's dive right in. So let's start there. What is law? You'd think there'd be a simple one-sentence answer for that, right? Something you could just look up in a dictionary. Well, as you're about to find out, it's not that simple. Not even close. I mean, listen to this. The legal theorist Keaton basically said that trying to define law is like forcing the whole idea of law into a straitjacket. A straitjacket it's constantly fighting to get out of. So if the experts can't nail it down, you know it's got to be complicated. And that's really the heart of the issue. There is absolutely zero consensus. You have some of the greatest legal minds in history all looking at the same thing and coming to completely different conclusions. And this isn't just some minor academic quibble. It gets to the very core of how we think about justice, rules, and how society even works. For instance, you've got the jurist Roscoe Pound. He looked at law as basically a tool. For him, it's not some grand abstract thing. Nope. It's a practical machine that we as a society built to fix our problems and get what we need. It's all about function. But then, you can flip that idea completely on its head with someone like the Roman statesman Cicero. He said, hold on, we don't invent law. He believed it's a universal truth, the highest reason that's already woven into the fabric of the universe, and our job is just to find it. And then for a third, completely different angle, there's John Austin. He saw law as just pure command. Simple. It's a rule made by someone in power for everyone else. If a sovereign didn't command it, it just isn't law. End of story. So you see, three brilliant thinkers, three totally incompatible ideas. Okay, so how do we make sense of all this? We can start by grouping these clashing ideas into a couple of big debates. The first is formalism versus realism. Formalists think law is like math. A judge just finds the right legal formula, plugs in the facts, and gets a predictable, logical answer. But the realists, they're like, get real. They argue that law is messy, it's human. Judges aren't computers. Their own biases and beliefs will always play a part in the final outcome. The second huge conflict is between positivism and naturalism. This one is all about whether law is connected to morality. Positivists say absolutely not. Law and morality are totally separate. If a government passed a law, it's a law. Doesn't matter if it's good or bad. But naturalists push back hard. They insist that law and morality are intertwined. For them, an unjust rule can't actually be considered a true law, and our ideas of law have to come from things like reason and conscience, too. So, this is a mess, right? If the greatest legal thinkers ever can't even agree on what law is, what hope do we have? It kind of feels like we're at a dead end. But what if we're just asking the wrong question? Instead of what, let's try asking where. Where do we actually find the rules that run our lives? Now that's a question we can work with. And this is where things finally start to get clearer. To slice through all that philosophical fog, we can turn to a framework from a legal scholar named Salmond. He decided to sidestep the whole what is law debate and instead just created a practical map of where our laws actually come from. It's a super useful way to see the concrete origins of our legal system. Salmond basically said that our laws are produced in four main factories. These are the primary sources that give law its power and its substance. They are legislation, precedent, custom, and agreement. So let's break each one down. First up is legislation. This is the one you're probably most familiar with. This is law that's made on purpose. It's when a parliament or a legislature sits down, writes out a rule, and makes it official. You know, like the laws that say you have to stop at a red light, or the tax code that tells you how much you owe. This is law by design. All right, the second source is precedent, and it's all captured in this incredibly powerful Latin phrase, stare decisis et non quieta movere. It means to stand by decisions and not disturb the undisturbed. You can just feel the weight of history in those words, can't you? So what does that actually mean? Well, that's the principle of precedent. It means that when a judge decides a case, that decision becomes a new source of law for other judges to follow in similar cases down the road. It's all about consistency. For example, the whole idea that police have to read you your rights, that didn't come from a big law passed by Congress. It came from one landmark court case that set a precedent for every single case that came after it. So in a way, judges don't just interpret law, they actually help create it. Third on our list is custom. Now, hold on. This doesn't mean just any old habit becomes law. For a custom to get legal recognition, it has to pass a really tough set of tests. It has to be reasonable, it has to be clear, and it has to have been going on continuously for a very long time. And, crucially, it can't clash with any existing written laws. Think of something like common law marriage, where in some places, just the long-standing custom of living as a married couple is enough to make it legally real. And number 4, our final source, is agreement. This is law on a much more personal level. It's law that you create. Every time you sign a contract, you and the other person are basically creating your own little private set of rules that are legally binding. When you take a new job or sign a lease for an apartment, you're tapping into this very source of law. So, what's the big takeaway from all this? The most important thing to remember is that law is not some dusty old book of rules sitting on a shelf. It's a living, breathing, constantly evolving system. It's being built and rebuilt every single day from all of these different and sometimes competing sources, from huge philosophical debates and acts of government all the way down to a simple contract you sign online. Which brings us right back to our starting point, but now with a totally new way of looking at it. So I'll leave you with this question. After all that, what do you think? Is law a science with objective truths waiting to be found, like the formalists and naturalists might say? Or is it more of an art, something that we humans create and shape and argue over, like the realists and positivists would suggest? The debate, as it turns out, is far from over.